Hello, good morning, everyone. Uh, is my voice clear and audible? Hello, is my voice audible? Can I get a yes in the live chat? A very good afternoon to all. We will be starting in a minute. Welcome to the webinar. It gives me immense and great pleasure to welcome you to this webinar devoted to the topic of international water law. And I would like to tell everyone that this webinar will be completely in black and white theme. And I have done this because if we are talking about law, so what's better to go with their colors? Because if anyone is not aware about that, so I would like to convey that black represents submission of oneself, just like a priest or a devotee does to the god, and lawyers wear black to show their submission to justice, and the color white signifies light and goodness. So this will be a different experience for everyone because there will be no colorful templates or colorful slides. It will be just black and white. I hope it will be good. So while starting, I hope that you will enjoy this webinar, and I will look forward to getting to know you through this webinar. And I would love that everyone in this webinar, please share your views in the live chat. Don't wait for the end for the question answers. Just if anything you want to me to start with, or you want me to convey the message, I would love that please open up in the chat, and I will be seeing each and every message during the webinar also. And if you have any opinions, suggestions, or if you want to know anything about, or if you have doubt during the webinar, so feel free to tell. Just last one time that yeah, is everything is audible? So so yeah, so access to water is a crucial issue. It is an issue intrinsically linked to the multiple uses of water resources. So questions of access and uses of water resources have a great impact on economical, social, cultural, and political contours, but have also legal facets. So if, because everyone is talking about the challenges or the water management issues or the water crisis that is happening all around the world, but are we aware of the international water law? Are we aware about these consequences the water law faces in all around the world and in our country as well? So it is very important to know that how this international water law all around the world works, and how the what is the origin of it, what are the challenges have been faced during the formation of water law, and how this has to be looked forward, because this is our generation actually are not aware about the international water law, and we are not aware how it works. And this webinar is an open course, is based and designed on open course, because I will be covering the content which will be accessible to both lawyers and non-lawyers, practitioners, or even students. In fact, I want to say it is for anyone interested in the issue linked to the international protection of water. So in the past years, I have heard these type of questions that what are the conflicts happening between India and Pakistan, the water conflicts that is happening, and what are the conflicts that is happening between China and India, or the other transboundary water conflicts that are happening. So it is very important to look about the challenges that what comes in the management and protection of transboundary water resource. So, water is a resource with specific qualities. You cannot compare this resource with any other resource, because every natural resource, or every non-renewable resource is a different type of resource. So, water is also a different category of resources, and water is completely different resource. And there are many specificities, numerous specificities that leave their mark on the international regulations, and which govern how this resource will be used, because it is very important to look after that how the water will be used over the coming time, and how everything will be looked forward. So firstly, I would like to tell water is a finite resource. And what do I mean by a finite resource? I mean that it is a resource that always exists in the same quantity. It is never like, and after 10 years you will see that water is less. No, water is a finite resource, that water will remain in the always in the same quantity, because if the groundwater is depleting, the glacier's water is melting. So on the same scale and on the same point, the groundwater is depleting, there is water stress for the drinking water, but actually looking at the broader perspective, the glacier's water and the ocean water is increasing. So it is very important to understand that it is a finite resource. So you cannot have more water except if water is created, but actually it's impractical. If we say water can be created from the atmosphere, water can be created from the vapors, as the new technologies and new innovations are coming, but this can only be done in a very limited way. Or if you have heard about the desalination of seawater, it can be done. But when we see that water is a finite resource, it will never be less and it will never be more. But you have to return that the main idea, I think that what is important, that water is a finite resource, the quantity of which is always remain same. However, the stages of water, the forms of water are able to evolve. If I say that in the liquid state, the water is decreasing, or the drinking water is decreasing, maybe in the solid state or in the vapor state, the water is increasing. So the quantity of which is always the same. As rain, it can infiltrate the soil. These are different stages and forms of water are known as water cycle. And I would not stretch about water cycle because everyone is aware about the water cycle, but this needs to be considered, because there is increasing pressure for more and more water. As day by day the population is increasing, and the day by day we are looking upon the more water stresses. And in my earlier webinars you can see that how water stress is a very big issue, and how day by day as the population is increasing, we are facing a water stress. So we need to remember that the quantity itself cannot evolve. And another particularity I want to talk about this resource, that is unevenly distributed. It is uneven. Like in India, maybe this much amount of water is available for the this much amount of population, but in another country it will be more available but less amount of population. So it is very unevenly distributed. So as we have the huge population, but we don't have the huge water resources available for us. Whereas in other countries, there is a huge water resource available, but there is not huge population there. So this is a very big thing, and that's why the trans boundary resources came into existence. That how we can use the resources that are above everything that we have. So, and all of this must be taken in account, because as you know, we all need access to water for different uses, and this can be a source of tension or conflict in the coming times. Because as the climatic conditions are changing, and as the, there is a progress, so there is a different change. And another aspect I want to talk is over exploitation of water resources. We will talk about this later, but there is a multiplication of water uses. There is always, when we see the data, there is these are the challenges I am talking about. That as the data we see, the multiplication of water is happening, and we are seeing that how the water usage is multiplying, whether it's for irrigation or industrial means, for energy production or other uses. And there is a great appetite for water and its different uses, so it is overexploited, and at the same time it's a finite resource. So just think that of finite quantity, so it is not possible to create water. But there is also another aspect that needs to be taken into account, and very often water is wasted. We don't count the water that is wasted during the usage, and we don't find that how the water that is being used in the specific domain, the what are the losses that is happening. So you may encounter different statistics, but very often you will hear about that there are 280 international water courses. Yes, the what are the water courses I am talking about? That all the oceanic, all the lakes, all the water bodies that are present. There are around 280 international water courses. And if you will see that almost 40% of the world population depend on access to these transboundary water resources. Now just imagine, the more than 40% the population is dependent on transboundary water resources. So we need to look on these challenges and to the benefits of transboundary water resources, because it is very important that how the world's population can access them, how it can be used in a possible way, so that the people, those who are interested in international rivers, or international water courses or international lakes, can realize and can work on that with the proper law. And I would be talking about every aspect of law in this webinar, that how water law is a very big thing that we are looking forward. So these particularities means the international law requires very particular content. You cannot say the international law that is applicable in India or in any other Asian countries will be applicable in any other American countries. Or maybe if we just divide Asia in Southern Asia, Eastern Asia, we cannot just say that these international water courses or the international law will be applicable to all the aspects. No. So we have to design an international law that will be applicable, and its content will be applicable for each and every country. And for each and every particular river basin, there should be a different scenario. So it's very important to look into that manner. And I'm also thinking about when we are talking about the challenges, it's very important to talk about the human rights. Yes, when I'm talking about human rights, water is a part of a human rights. And for all the human beings or the mankind on the planet, uh, the water is an entitled resource. Like, yes, everyone can use it, but we have to look upon the private and public investments, what is happening for the groundwater usage. And we have to see that what is the groundwater international water laws that is happening in and around the world. So it is very important to look on all these aspects and all these issues. So now, after looking, this exists in very different level there, which I will answer afterwards. But there are multiple issues and challenges for the rule of international law. And I would also like to highlight another challenge, a challenge that has taken on increasing importance within the international community. This challenge is the relationship between water and peace. Now, when I'm saying that the relationship between water and peace, water and international security, and I have already mentioned the finite amount, a distribution that is not geographically equal because of geophysical or climatic conditions, because the overexploitation is also a great factor on different countries. Because if we see the data or strata, the people are not in India, people are not aware about the challenges the water resources are facing, and there is a huge overexploitation. But in many countries, the people started organizing the water resources and started managing the water resources, and the United Nations are increasingly taking into account the water and its potential sources and how that can be settled over the time. Now, when I talk about the challenges in the management and protection of transboundary resources, so there will be a huge number of things that could be the possible cause of conflicts and that could be worked upon. Now, when I talk about this thing and how we can deal with this, because as the whole webinar of consider will show you that how an overview of what the challenges are for the both the management and for the protection of water. Now, I will be talking about when we are talking about challenges in the management, the main thing that comes is the transboundary water resources as a possible cause of conflict. Now, when I'm saying a possible cause of conflict, it is very important to know that what is conflict. Conflict is any issue or anything that is being arising on a certain domain or a certain sector between two parties or between three parties or between multiple parties. So it is very important to look on this factor, because water and war are certainly a fascinating subject. On one side, you have water, which is indispensable for life. On the other side, there is war, which can endanger the supply of drinking water to civilian populations. Yes, if I talk about the 2019 case between India and Pakistan, yes, India threatened Pakistan to stop the water that is going in the dams, from the dams to the Pakistan, and it could affect around 20 million people. Yes, and this is a weapon of war. If you are talking about as a transboundary water resource as a possible cause of conflict, this could be a very big scenario when we are looking towards a greater as a potential weapon, because water plays a weapon in many wars. Several studies exist which have emerged from the United States that view the relation between transboundary water resource and war. And I would like to tell that is around 300 examples I could give you about the conflicts settling with water that happened in and around the world, and how these conflicts and how these things actually affect and actually take place when we look about the issues that are rising. So I'm going to begin by analyzing those theories that view water as a potential instrument of war. And secondly, I will examine water as an instrument of peace. And thirdly, in conclusion, I will provide examples of water as an instrument of peace during armed conflicts. Because during in the time of 1990s to 2000, how the scenario changed over time is a very important topic to be talk about. Because I would like to tell that in 1967, the conflict happened during the war between Israel and Arab countries, if you know, and the Israel's desire to appropriate water resources situated with Golan Heights. Yes, the Israel stopped the usage of the water for the Arab countries, and this is just one example. In 1982, Israel wanted to control the Litani River, and because the Israel is doing this from a huge from a lot of time, since the ages, that how the changes are coming and how the people are using water as a weapon is a possible cause of conflict. Because this water wars have been the situation have arisen and in many countries, and we can see that how these factors could just change the world, and how these things could just give a huge shock on the world's forum. Now, this map you can see. I would like to say that in the first emblematic example is the case of 1960 and Indus River. So Indus River, India and Pakistan, if no one knows this 1960 Indus Treaty between India and Pakistan, this treaty, the committee continued to meet even during the military confrontation that took place between these two countries. And this was a very big issue that happened between India and Pakistan, and there was a huge war situation that arises because Pakistan said that India won the war, and this was the scenario because this was a very big thing that happened Indus River Treaty. And I would like that everyone please go and check and read about the Indus Treaty between India and Pakistan if you are not aware about the situation. Now in this Mekong River, this is in the Cambodia, Thailand, Vietnam, the case the Mekong Committee, which continued to meet during the conflict in Vietnam. This case refers to the organization problem, that what the inter-organization or inter-state problems happen during this area, and there was a huge stoppage of water in the Mekong River in this situation, in this scenario. And it is very important when we are looking on different countries that how these things are affect everyone. About the heard about the Nile River is the largest river in the world, and it is just covering the entire Africa. And there were many situations that arrived in the Nile River, that how the interstates the disputes happen, how the pollution over the time increased in this river. And at this point of time, because if I looked back before 50 years, the whole country was just whole continent, I would say that it was dependent on the Nile River, and everyone was just using the Nile River water. But I will not say that Nile River is scarce or drought, no. But the Nile River water is so much polluted, is full of oil and grease, because they were not able to impose law on that on the correct time. And there were many dialogues that happened and many things that happened during that river. Now, the Senegal River, I would refer this case is the organization for the department of the Senegal River, where Senegal and Mauritania maintain dialogue by the organization even during military confrontation. The military came and the war situation happened, but they just say that they will not allow the water usage for the other country, and there was a war situation. I already told about Syria and how these things happen in all over the world. In Yugoslavia in 1948 convention, where the clashes happened and the war happened in Yugoslavia, the Security Council decided just to put this thing away. And there was a book named as The Time of Peace, and in which you can see that how wars were associated with water resources, and there was nothing to make that war stopped, or there was nothing to solve these wars, because it was impossible to impossible to solve that issues during the war. There were no possible things that could be looked upon. Now lastly, in this challenges and benefits, I would like to cover the benefits of cooperation on transboundary water resources, and how this thing affect. We all agree that fresh water is essential to human life. As long as we can be remembered, humans have benefited from the resources to ensure survival and to improve their well-being. However, the quantity and quality of benefits that can be derived from freshwater resources depend on how we are using the resources. Because it is very important that we have to look at how states are benefit from the shared management, how cities, how the intra regions are benefited from these transboundary water resources. It is very important that we looked upon the all the categories of benefits, because these four categories of benefits which I have distinguished are the benefits of the shared water course itself, and the benefits to be derived from shared water course. Because if we are seeing uh, the benefits of shared water course, we have to see that at the long term, when these water courses are shared, what will be the benefits after years. Because we always see in the terms of what will be the losses. Because if we are using someone else's resource, the first law that will come, that this water resource usage should not be a problem in the coming years. It should not be the problem, it should not be the pertaining problem in the coming years. But it is very important to look at how these things will help as a cost reduction, will help as a prosperity for people. Because when we are sharing the transboundary water resource between states, if we are sharing transboundary water resource between India and Pakistan, we have a war conflicts, or we have the ideas clash with the Pakistan, but we don't want that their people die. Obviously, no one want the humanity loss. We will never expect anyone that if we are going for a war or anything, there is the loss of life. So there should be many things that have to be looked forward, because we can do anything. We can stop the water usage for any other country or any other neighborhood countries. But it is very important that we look that how in the benefits to the shared water course itself related to the environmental benefits for states, because they cooperate to preserve the aquatic environment. For example, this might include the provision of safe drinking water, or perhaps good quality water for recreational activities. Because if we are using water for personal usage, there should be the appropriate quantity and quality of water. It is very important that we looked upon this issue, because the shared water can cause water course can include economic benefits. Because if we are using the water and if we are selling the water, we are exporting the water, that's also a huge beneficial for the economic benefits. And I would like to tell that India exports a huge amount of water because of its rivers and the great mountain water that is coming. And the hydroelectricity power generation is a very big economic thing. Because as you have seen that in Kota or in the Chambal river, there is a huge hydroelectricity power plant, and it gives an immense power, and people are using it for great usage. And it saves a lot of fuels and to a lot of fossil fuels that has been used. Now, when we are talking about benefits in terms of cost reduction due to shared river management, it could be derived from improved flood management or alerts about pollution. Now, if you will see that at this point of time, there is the flood situation going in Bihar, and in Assam. There this flood situation going on because the water that is coming from the Nepal side, the waters that is come, and there is many rivers and dams that have been constructed. Now, just imagine if the water that is coming from our nearby countries, they could already in the before time they can tell that our dams are full and the water is going to be released during the conflict. And there is the flood situation in Pakistan as well, because the water that is coming from the behind. So this is a very these cooperations between transboundary resources can stop, and can the people can be benefited from these flood situations. Because if by beforehand, if Nepal just informs us, and if the Nepal just tell us that there will be a flood situation in the state Bihar already, because the water is coming from that side, for example, so that flood situation can be avoided. That's what the alert about that's about the flood management alert, or alert about pollutions that can be happen. If you know that in Russia, there the whole oil refinery, the tons of oils were leaked into the river. And can you imagine that that will take around 100 years to be clean? But if the states already just tell the people that this is going to be happen, and this is the repercussions of that, so it is very important that it will be looked forward. Now, in 2015, a very informative guidance note produced by the Secretariat of 1992 Convention on the Protection and Use of Transboundary Water Resources and International Lakes recommended an approach to identify the benefits of cooperation within the field of transboundary water resources. Now, just imagine then in 1992, the first water convention happened, and I have shared the document and article regarding that 1992 convention with you all. And I would love that if you are interested in anything about transboundary water resources and water law, and I know that the people are attending this webinar are interested and are very keen to know about this thing. I would love that you all people just go and see that article which I have shared with you, because just imagine that in 1992 the convention happened with, on the use of transboundary water resources, but now in this time in 2015 there was informative guidance that how this thing should be actually taken care of and how this thing should come into existence, because people were not aware and people were not serious about these things. Because if cooperation of transboundary water resources is taken into consideration, it would be the responsibility of the national authorities, it will be responsibility for the local authorities, and for the central authorities of the states, or the local actors, for both states and non-states. There would be involvement of experts from different disciplines, because we need people from hydrologists as well, from political scientists, from economists, sociologists, or maybe law. We need every sort of people when we are dealing with transboundary water resources, that how this situation will help us over time. Because this is a very important thing that we have to look in the coming times. And in 1977 agreement, I would like to tell everyone that the establishment of the organization for the management and development for the rivers that came into existence. And in the document I have shared with you, you can see then in Article 2 that the organization will handle all matters relating to the activities carried out in the river basin, including the benefits such as development, potential of hydroelectric power, or the development of agriculture, livestock, and fisheries, and extra things. So why I'm telling you this, that it's very important when we are looking upon that how these agreements over the years, I'm not talking about 1 or 2 years, but over the 50 to 60 years, how small agreements that took place and how small conventions that happened, and that brought us to the international water law, and how the University of Geneva, the Water Geneva hub, helped the world in this very much thing. So, however, the quality and quantity of the benefits of cooperation on transboundary water resources relies on meticulous work, and we need to identify and the benefits also, and identify the usage also, that how the relevant uses for the basins, or the rivers, or the shared dams, or the hydroelectricity power generation, how these things can be applied with the law, and how we can maximize its benefits, and how this complex process can be made into a reliable process. And you cannot just release it in unilaterally. No, this would be everyone's thing, and everyone should look after this, that how we can look and how we can work on this actually. Now, when we see the multiple utilization of transboundary water resources, that how in terms of I would be talking about in terms of plurality, since the uses are many and are varied. Because I cannot just say that this is the specific use, the washing is the specific use. No, when we are talking about washing, we are talking about a greater aspect, because there are so many things actually when we are talking about just the issues. So the first issue that we international water courses see is the navigation. Yes, the navigation is a very big issue and very big thing. And when we talk about navigation, this it was the first uses that was addressed by international law. That what how navigation could be the big next future thing when we see that you in the utilization of transboundary water resources. Because in the political situation in the 19th century meant that European countries considered navigation, transport, communication as a means of economic development. Yes, and it was very important, because now also economic countries just focus on how the navigations and how the transport and communication can happen in people. Because if you have heard that in Italy, in the COVID situation, there were so many cases, but as the cases reduced, the European countries started the tourists and they started promoting the tourists. And they are paying like around 50 euros to each and everyone that, and vouchers that go and travel in and around the country, because they are promoting the tourism. And they were always in the support of how there will be the free movement, free navigation. And it is very important when we are talking about international water courses. And if we are going from one water course to another water course, there should be free movement, free navigation, in principle, when we are looking this factor. And when these things have to be looked forward, and when these things have to be taken place, it is very important that we look how these things can be a big factor for everyone present. Because when we are seeing that how everything and how every issue should be looked in a greater perspective, it is very important that we see this issue. Because in 20th century, the international law addresses additional uses. They addresses the economic development, and which follows in the prolongation of industry revolution. Because yes, if we are seeing industry revolution, we are sharing electricity. The Reliance is generating electricity, and they are not just generating for their own home, they are generating for the entire city or entire state. And it is very important to look forward to this type of things, because if someone is developing anything, and if there is hydroelectricity generation and the plant is in one city, uh, it is more than enough for that city actually, and it is more than enough to cater that city. But we have to look that how this follows, and how the result of this should not be end in a lot of pressure. It should be ended in the benefits mentioned. There should be better irrigation for that area, which is extremely important to feed the people. And it is very important to look at how these scenarios are very important that we look, and that we see in the coming time. And that these things should be looked forward. Because when we acknowledge the relation between these uses, it is very important that we looked at how these things actually took place. Because in the 1997 convention, negotiated by the International Law Commission, there is a very huge important and variety of the principles that took place, and the many things that happened during this time was taken into consideration. And the commissions were set up, and in this article 10 was introduced of the 1997 convention, which just clearly mentions that how basic human n- needs to have the priority. Because when we are looking upon the domestic usage, that's the first and the most important usage. And it is very important that we look forward to these type of issues. Because if we are creating some law, everyone knows, I have so many lawyers which are attending this webinar, or the future lawyers. Everyone knows that when we are dealing with some sort of cases, and when we are approaching a case, we need to understand the positive and the negative aspect. We need to understand the depth of that case, because it is very important that if we don't know the actual cause and actual case related queries, we cannot handle those circumstances that could be arise. Because when we are in the case, or when we are in the court, any situation and any issues that can be arise. So when we are thinking about the International Law Commission, they have to look about the all the possible aspects that this could be happening, and this could be an issue in the coming times. And we have to meet all the basic needs. And we have to be assured of sanitation. We have to assured of the domestic needs, and we have to be make the people also assured that this treaty, or these are the principles that has been said, will not affect and will not be the cause of problem. for other people. So this is very important. Now, when we are talking about the things that could have been the in the problem. Now, wetlands of international importance, yes, in the Ramsar Convention, and if you want, I can share you with the articles of Ramsar Convention, which protects wetlands of international importance. Yes, now what I am talking about wetlands, there are many seas or many oceanic boundaries or many structures that are created naturally, and there are many lakes that are created naturally. These are the wetlands of international importance because people all around the world see and come them, and they have the historical significance. And it was and why I am saying that it is of international importance, because in these water courses there are aquatic animals, and these are the habitats of many of aqua and fauna, and these have to be protected because water resource, because they have significant habitats and the whole ecosystem they have created. This cannot be affected by any domestic usage as well, because this is a very important thing, and this should be also included in international environmental law. As you know, many land borders are defined by characteristics of the land, and sometimes there are international water courses. Strictly speaking, this is not a use. However, nature doesn't care about these borders, and again, states need to cooperate to ensure that water resources can be used in the best possible way. Because if the country is dealing with another country, the states of the country also needs to look after that. Because if we are sharing water through Punjab, India, and to the Pakistan, and if the Punjab border just say that the our rivers will not pass to any of the place to the Pakistan river. So these things should be taken into account, and there should be water borders, but there should same time we should respect the political borders that should be agreed. Now, the last thing that I want to talk on this topic, that the characteristics of the utilization. Now, what is the characteristics of the conflicts between utilization? Now, what is this which I am talking about? That one of the biggest example of this type of conflict that I am talking about is these the conflicts are divided into horizontal conflicts and vertical conflicts. Now, when I'm talking about the horizontal conflicts and vertical conflicts, it is very important when we look upon the challenges of both horizontal and vertical conflicts and how these things actually happen. And because in the when I just talk about for example, if you see the example of Lake Lennox. Now, Lake Lennox is the type of horizontal conflict, a case that dates from the late 1950s, when France and Spain were in conflict over the use of Lake Lennox. Yes, this is of that era, and was between France and Spain, because France wanted to divert the water for the production of hydroelectric energy, and Spain opposed this because they believed that the water of Lake Lennox should be used for irrigation. Now just imagine there are two big states, two big countries, and they on the one lake they are focusing on that yeah, how this Lake Lennox should be used. And the France was just and adhere to this situation that we will use it for hydroelectric energy, whereas Spain said no, it will be used for irrigation. And yes, this is true, when we use the resources for hydroelectric energy, there is some water exploitation and there is aquatic exploitation. So there can be a conflict between states, such as the states alongside and the international water course should be used. But when we talk about a horizontal conflict of use, we need to look at the actors as well. What are the actors? Actors are the individual constituent of the assembly. When we are talking about suppose a state when we are talking about the capital Delhi, and the who's actor of it, it's our CM, Arvind Kejriwal sir. And it is very important to look after what he's saying, and what the outlook of his ideology is actually, because he is the actor of that state. So this is very important that we look alongside that how these international rivers are member of states of the same river basin organization that may not agree on the international water course should be used. And as I have told you in the earlier side, the example of Senegal river, it's also a very good example that how the Senegal river has been used over the time, and how there will be was the development between these rivers. Now when I talk about this the Nile is an example of a vertical conflict. As I said earlier, alongside horizontal conflict, there is also a category of water use conflict that could be desired as vertical conflicts. Now, when I'm talking about vertical conflicts, in this category, one must first identify the conflict between the current use of an international watercourse and the future use of an international watercourse. Now, horizontal conflict, that's the conflict that is running parallelly. So that's the conflict that is running in the same time. The France and Spain want the usage, that same usage in that same time. They don't need another different usage. But when I say that in the situation of Nile, the situation arises that what will be the current use and what could be the potential future use. So it is very, very important that when we look upon these two types of conflicts, because when we are identifying this in the international water course, we have to look that within customary international law, in principle, there is no hierarchy of uses. Yes, there is no hierarchy of uses. It is never like that. In the older times, the Nile was used for this purpose, and in after 100 years also, the Nile will be used in that current use only. So there is no hierarchy between present and future uses. However, in practice, state sometimes claims a hierarchy, and this can lead to conflict, because if the Nile is going from Aswan or Egypt, so if Egypt people say that no, we use this Nile river just for the industrial purpose, we will not use it for domestic purpose, or we will just border it, and so there, I would like to say that in this example of the Nile, there were two downstreams states. The water is going from Sudan and the water is going from Egypt. And they believe that their present uses, their current uses, take precedence over future use. And now, what is precedence over future use? That when they are using this water in the current situation, so maybe after 10 or 15 years, or maybe after 30 to 40 years, they would not be able to use that water for that usage or for any other usage. So they are thinking of it as an hierarchy, and that's why the states starts bordering the Nile, and this of course generates a lot of tension in the management of the Nile, because when I am saying that Nile is a river for the entire country or entire continent, where we are talking about Africa. So this category of vertical use conflict is huge. In this conflict, emerge between the uses of states, and this could envisage the usage, and this could affect the users, actual users, because when the shared water course used in the more intermost dimensions or interstate dimensions, so there will be where there will be very, very uh, conflicts arising in the local community, and there will be the conflicts arising in the actual growth of that place. So, as the river was not directly concerned, the conflict here did not create relate to use. Actually, there is no conflict between the use of river. There is a conflict between the future use and present use. No one is saying that it will not be used, but people are concerned about that how it will be used in the later time. Now, when I'm talking about uh, now, this is the time when we talk about the codification of the law. which was applicable on international water courses. It is very important to look on this issue, and it is very important to look on this aspect, that how the codification of the law happened, and how this thing came into existence. Because I would like to tell that this started around in 1960, and the first thing that happened, and when we talk about the origin of codification of the law applicable to international water courses, this initiative was undertaken by a professional group called Institute of International Law, and in its Salzburg session that happened in 1961. Why I'm telling you this information? Because it is very important. Because when we are understanding in the starting of the webinar, I told you about that what are the challenges and why we need the transboundary water resources. But now I'm conveying you with how and what the code, how came into existence, how the law came into existence with the water. And this there was a professor Andresi from the University of Zagreb, and he was the great specialist in water law. And this resolution, this Salzburg session planted the seed for what comes later. Now when we see, and then when we look on the approach, that it included the principle of equitable and reasonable use, which was not yet defined. Because in 1960 he told that there should be an appropriate usage, and there should be the professional association. And he said that there should be a professional association, and how the initiative should take place. Because when in 1961 in this session, he said that there should be a criteria, that how there should be equitable and reasonable use of water resources. But at that time there was no such law defined, and there was no such principle was there. And the second thing which was very important, what is not there, that the rule which prevents one riparian estate causing damage to another riparian estate. Now what is riparian estate? Riparian estate is the state which is using any type of water course or the river water in its estate, and which is using a transboundary water resource. Now when I'm telling you, and when I'm talking you about that riparian state, and how riparian state could be looked forward, and how this issue is very important, that when one state is using another state water, and the other state is actually exploiting that water, that law was not there until 1966. The initiative was started, and the initiative was taken, that how the resolutions can be taken, and how this thing could come into existence. Then a very important role, not only for international water course, but for the entire country. The conventional practice started in the certain states, Switzerland, Germany, the United States. And the main principles, that right to equitable and reasonable participation, and also prohibition to the any damage, that came into existence. Now when we are talking about how this thing happened, the contribution of the Convention on the Protection and Use of Transboundary Watercourse and International Lakes of 1992 to the regulation of transboundary water resource. This is the whole article that I would be now discussing about, and I have shared you with this article, because in this convention in 1992, and this convention is also known as Helsinki Convention. And the lot of people discussed about this convention that happened, and it was adopted in 1992 in Helsinki. Helsinki is in location. uh, it came into force in 1996, and now it's almost 24 years, 25 years. And now this convention and this protection act has around 41 parties to the convention, and around 40 countries. and plus the European Union. Yes, the whole European Union is with them. And it is very important to emphasize that these parties are sometimes upstream, sometimes downstream, and this is important in the context of cross-border cooperation. And why I'm telling you that sometimes upstream or downstream, because it's not correct to say, and it is not correct to include that if India is cooperating with them, that India will cooperate with them. No, they, as you have heard, and there are many things when we look about the transboundary water resources, and we look upon the issues that is happening in and around the world. When India signs a treaty with any other country, we see, and there is the news of that all around, that India has signed this convention on this with this country. But when we look on a greater perspective, that do we get to know that the treaty has been broken over the years, because the treaty is never a lifetime sharing of any negotiation. No. So uh, there is always you, this is a very ongoing process, because when a treaty is signed, it's a very ongoing process. It is not like that once the treaty is signed then there will be no complications. No, when the treaties are signed, there is always the cross border cooperation, and there is always that how these things should be or looked forward, and how it is very important that we looked into these issues, because the convention was originally negotiated as a regional cooperation framework for European countries. But in 2003 it was amended to allow memberships to any UN member country. So over the time, first it was for just European countries, because at that point of time they were involving at a greater perspective. But in 2003 they allowed the membership for any UN countries as well. So, this convention includes the obligation to prevent and reduce transboundary impact, to ensure an equitable and reasonable use of water resources, and to ensure cooperation through common agreements and joint bodies. Yes, so all these things were included, and the main obligation that comes to fruition. In any case, ensuring sustainable water management is the main objective of the cross-border cooperation. Yes, after all and above the all the cooperation, the transboundary water resource management includes the sustainable water management. They said that you can do anything and you can go with anything, but it is very important that we look to the transboundary water resources, because if anything could happen and anything would be happening, there is the most important thing is that the water should be managed in a sustainable way. There should not be anything that affects the country at the later level. Now when we are talking about this, it is very important to talk about the role of civil society in the ratification process of the United Nations Convention in 1997. So now my first question that came into my mind, that what role did this organization play in the ratification process? And the same question should come into your mind, that how United Nations Convention actually helped people, and how all these things actually help. So I would like to just ask one question, and to everyone, please just write in chat that what do you think, that what role did the organization or the civil society organization play in, you can talk about in the country as well, and you can talk about in the other states, or in the central level, that how the civil society plays a big role in any law formation or in any way. Can I see the opinion in the chat, please? Yeah, so the role of civil society, as when we are referring to the United Nations Watercourse Convention, and at this point of time there was the NGO Green Cross, and if I don't think that you have heard about this, because in 1993 this came into existence, that how there will be they started the Green Cross Association. It is just like the Green Climate Fund or the GCRF. So this convention directly was promoted, and the legal governance of water on a global scale, they have taken into assurance that how the legal governance and how uh, uh, the essential human needs and population will be prioritized, and how when we are looking on the convention, which already mm, see that how these things will be looked after. So we face several difficulties. First of all, as surprising as it may be, in the 1997 uh, convention, we face several difficulties. First of all, uh, several years after its adoption until very recently were not well known. People actually don't know that how these things will be worked upon, and there were roughly 15 states parties to be with the link to the framework agreement, because when these conventions started in 2003 or in 2013, the people were not aware about these laws, and people were not aware about the situation. So there were also so they started openly promoting, and this would be was extremely useful because there were political contribution. And then the UN convention comes in the force, and when the UN convention came into the force, then everyone got to know, and then everyone got to understand this thing. And this phase where we continue our efforts, now we are seeing that how these issues and how we can look forward to these conventions, and how this could be happening within around the world, and how promotion could took place, that how the international water law will be developed in the coming times. It is very important that we look after these issues, and how the evolution of international law with a specific interest in the case of groundwater. Now, when we look upon the groundwater, that the cases of groundwater resources and the challenges linked to the regulation of groundwater resources. So, I'm going to talk to you about groundwater. The first thing, that the challenges of groundwater regulation, and I have identified two challenges. Well, it concerns borders, and first is to knowledge about groundwater. People are not actually aware, and people are actually not knowing about the groundwater resources, and people actually don't know about the situation that is happening in and around the world, that what is the situation of the groundwater, and how they have to look, and how these things should be looked upon when we see the groundwater resources. So it is very important, because the groundwater is so important for the planet's fresh water supply. Fresh water, as you may already know, only represent 2.53% of the Earth's water, and the majority of the planet's water is salt water. Groundwater represents 30% of the mass of fresh water, and therefore it is a really large mass. We have about 2.5 billion people on the planet who depends entirely on the groundwater for the domestic water needs. And in some countries this can be 100%, like Libya in the arid zone, or the Arabian Peninsula. But even in Europe, where the climate is more temperature, 70% of the population depends on groundwater for its drinking water supply. Now finally, the groundwater extracted from our land, from the subsoil, and 65% of the groundwater extracted needs, there is no reasoning to it, and it is very hard to manage that how these things should be looked upon, because when we are using, and it is true that agriculture uses groundwater for irrigation, but agriculture also uses pesticides which infiltrates the soil and will affect the aquifers or the groundwater resource. And in France, in the region of Brittany, there are aquifers that have been polluted by agricultural activities. So it is very important to look upon that how in the legal perspective, that how there should be the proper consideration, because UNESCO initiated a project which allowed states sharing an aquifer to identify it, And moreover, they have started the initiative as well, that how the law can be imposed and how these things should be looked upon. And when we work at the work when we see that how the work of the international water courses and how the principles affect us. So, what was the concern when the International Law Convention came into existence in 1997, New York Convention, which was adopted by the General Assembly of the United Nations? It was very important to look after that how the articles were drafted in the international way. And in 2003, the special reports were introduced for the transboundary confined risk groundwater. So, it was very important that we looked upon how these all issues happen, and how we have to look upon all these matters on a greater way. So when we look and in the first reports that will look at the groundwater was not covered by the 1997 convention. Yes, when we are talking about international water law, and in 1997 convention you can see that groundwater was actually not involved, because as lawyers and professors of international law they were not aware about the actual groundwater usage, and they were not aware about when we are referring to groundwater that what is under pressure. And so, to avoid any misunderstanding between hydrologists and lawyers, this term was dropped. At the same time, after the consultation and hydrogeologists, we decided to adopt the term aquifer. Yes, so the aquifer did came into existence. Aquifer is nothing but groundwater table. So by the term adopting the term aquifer, the spatial reports that expands the subject no longer cover only groundwater. So when we are saying aquifer, we are just designating groundwater as unrelated to surface water. We are just confining that thing, and they're just confining that space. But when the United National General Assembly started this thing, and when we see that how the specificities of the law on the transborder water resources affected uh, affected the things. So there was a scope that was included the use of transboundary water required aquifers and measures of protection and preservation as well as management practice. And the articles were drafted that set the scope of 1997 convention. And in addition to the transboundary aquifer, new protection measures were introduced, and many articles because I mentioned in the second sequence that the choice to include the term aquifer in the draft article instead of simply groundwater had consequences. And that is the consequence. When you consider the aquifer, you have to manage all the activities that you may or have an impact on the aquifer. So definitions that are truly hydrogeological were too complicated for lawyers. But simplifying was an option because the sense of what an aquifer is needed to be retained. So it was very important that we, as in I, as in I, as in water resource engineer, or the person hydrogeologist, and the lawyers must come into the law that binds them. It should not be full of complex articles, and it should not be something that people don't understand, because if as a lawyer you are seeing this webinar, that it is very important that you looked on the permanent sovereignty over natural resources. You looked upon the assembly that resolved and that is adopted by the lawyers and by the hydrogeologists. So the states and the centrals can exercise sovereignty over the portion of the aquifer or of a transboundary aquifer system located within its territory, but there is still a limit to how this sovereignty is exercised. The state can exercise this in accordance with international law and the present articles, or they can just draft their articles and their version of draft articles according to their theme and according to their law usage. So it is very important that if we are talking in particulars of just law, that how international water law would affect the relation to equitable and reasonable use. And everyone who is there and who is working as a lawyer and as working will have to see that how their law and that how their usage of law can linked to every drop of water, because it is very important, because we cannot just change, and we have to look upon the future generation aspects also. Now it is very important to see the key principles of water sharing. The key principles of water sharing that combines two things, and I'm going to present the two key principles. Firstly, the principle of equitable and renewable use of waters of an international water course, and secondly, the obligation to not cause significant harm to the territory or the environment of an international water course. Now, equitable and reasonable use, in this starting we are telling you, is affirmed by Article 5 of the UN Convention on the Law of Non-Navigational Use of International Watercourse, and the articles I have shared with you. Now, this principle affirms that each state of an international watercourse has the right to the equitable and reasonable use of water, and the principle is also affirmed by several other legal instruments, such as the 1994 Danube Convention, or the 1995 Mekong River Agreement, or the Senegal River. So it is very important that we looked on this aspect, because any territorial development or any state development is very important to know about how these law works. And if you know that, and if you have seen, the International Court of Justice affirmed the general obligation, and there is a whole court of justice that works, and they also had to be aware about the international water law, because it's not just about this one thing. They should be also aware about the whole situation that is happening in and around the world. And when we talk about the principles of water law and administration, the it is very important that we looked upon the Article 10 of the United Nations Convention, and this states that if there is conflict over the use of an international water course, there is no prioritization of use. Yes. Now, when we are seeing that there is a conflict between the states over the use of an international water course, there will be no prioritization. If there is an complaint, or if there is an anything that has been filed in accordance with the conflict of water usage, then no one will see, and the court will not decide on the prioritization. There would be the actual court case, and there will be the jury that will be seen, and they will see all the principles and all the usage, because this obligation is affirmed in Article 7 of the 1997, and this principle is based on judicial decision. Now, cooperation between riparian states and the notion of the community of interest and rights. So, it is very important to know the principle of cooperation. Now, everyone knows, when I am talking to lawyers and to the professors here, that it is very important that a lawyer should know what the actual cooperation means, because if there is no cooperation, if there is no negotiation, then there will be no understanding between the uh, parties dealing the case. And it is the major principle of international water law, because when we see that cooperation between two states, and how what is the importance of cooperation is there, and I need not explain to the people that how cooperation can create a war, and how cooperation can stop a war. Because when we talk about the countries which the borders are shared with them, there is the possible way that each state has a different interest, and each country has a different interest. So it is very important that the importance of principle of cooperation becomes apparent in this case, and there should be a framework of cooperation, that the discussion that how these things could go, because there have been several examples in the past time that how the world has changed, and how there will be different, how there was different types of forms of cooperation over transboundary water resources, and how they take different forms. So it's the first thing that is that article in the article 8, these forms of cooperation are listed, and it is titled as general obligation to cooperate. So, in the first paragraph, if you can see that it affirms that states bordering an international watercourse should cooperate to ensure equitable and reasonable use. but also to ensure the river is protected. That means that although there is the state sharing of boundary, or there is the cooperation between water resources, it is very important that we look forward at how these things should be looked upon, and how these things will be taken into for granted in the coming time, and how the riparian states set up joint commission and mechanism that include riparian parties, and how within this framework or transboundary water resources management states are also invited to set up joint bodies. Yes, like for example, anything is happening in France, and they need to cooperate with Spain, so there will be joint bodies of France and Spain on, and the third party that will be mutual to their decision, so that everything could be taken into account. And Article 9.2 affirms that how the state should work, and how the establishment of joint mechanism on international water course would work with them. And these things have been clearly understood in the 1992 convention as well. Now this map I would like to show, this clearly shows the experience of the Senegal River Basin Development Organization, and on this is on the sharing of transboundary water resources. Now you can see here that this is the Senegal River that is going. This is the highlighted river that is Senegal going, and this is the valley area, this is the delta area, and this is the upper basin. Now just imagine that one river, there is three areas that is being divided: a valley area, a delta area, and the upper basin. But now just imagine that how the different countries that the river is being passed, and different areas that the river is passed in the small West Africa states. So there was a spatial river basin commission that was set up, and that is still today, that was the most advanced thing that has been set up, because this was very important to be set up, because there were so many conflicts, and how we have to manage the Senegal river, that was very important. So there was a convention that happened, and there was a specific commission that happened for this region, and it was very important to look after that. So now when we look on the water cooperation, there is the water cooperation uh, includes all these aspects, because these all thing comprises of water cooperation, because legal frameworks, transboundary institution, dispute resolution mechanism, data and knowledge management, water and the broader political context, practices of water diplomacy, and other things, these all constitute, and this all make the water corporation more effective and more working, because it is very important that how we look to this aspect, and how we look to this body. It's very important that how this thing should be managed, and how at the greater perspective, when we are aiming to the bigger approach, that how we will look forward to this. So it is very important to look after this. Now what is aims and modalities, this sequence I will focus on the importance of the practice. And I know that I'm telling this from long time, so we will be ending soon in just 5 to 10 minutes. That now this aims and modalities is very important when we are planning, or when we are seeing that how things should be measured. So in simple terms I would explain that what it is, that notification on planned measures. Now when any state, or any arbitral sentence, or any issues have been taken into point. Suppose when India and Pakistan is working on the water conflicts, or India and China is working on the water conflict, the component is the notification on planned measures. There should be the notification, and there should be the agreement or disagreement on every aspect. If India suggested some aspect, there should be one notification that there is a disagreement or there is an agreement. Because when we talk about notification and consultation, I think we should turn to the reference legal instrument. And it is very important that where we see the 1997 Convention article on the law of non-navigational use, and it is very important that we look forward to this, because when we are seeing, and we are seeing on the greater perspective how this could trigger and how the legal procedures could be affected on this thing, because the previous sequence dealt with the obligation to notify, and we see how in the case of plan measure the state proposing the measure must notify the other riparian state. That's the whole thing of notification, that anything that is happening, any there is a future risk, anything that should be consulted, there should be a notification on every scenario, then only the actual law should come into existence. Now a deadline is set within which the notifying state has to study the plan measures and assess the defect and effects and provide a response to the notifying states. So in this also the two scenarios may arise. The first scenario is that the notified state gives its consent. In this case, the notifying state may continue without any type of procedure and they don't have any issues. But the second scenario is that the notified state rejects the proposal. That's what I was talking about, that how there should be a disagreement or an agreement to the proposal. In this case, the state proposing the contested measure must enter into consultation or even negotiation. So there should be a triggering and conduct of the procedure on consultation and negotiation in the case of plan measure. So before examining how the obligation to consult and negotiation is implemented, it is necessary to clarify the terminology. So consultation and negotiation generally go hand in hand in treaty provisions, and I think that the all the my lawyer participants will be knowing that what is the difference between consultation and negotiation and how this thing go together. Because in water treaties, parties refer to the term consultation before a dispute has arisen, and it refers to the term negotiation only if needed. So, in other words, the consultation phase offers the opportunity to identify the potential disagreement between states. When there will be disagreement, then there will be consultation, and if there will be nothing be working, then there will be negotiation. That how the situation can be negotiation. And in Article 17, which I have shared in paragraph 1 of the 1990 New York Convention, it is clearly mentioned that if the state that was notified about the planned measure concluded that the planned measure is likely to cause significant damage, then the notifying state and the affected state will enter into consultation. And this is a very important thing. Now, at last, I will be talking about water and climate change, that how this thing actually affects every formation of the law. And it's very important that we look on this aspect, because water and climate change is very important that is happening in and around the world. Because when we are talking about the Article 4 of the Framework Convention on Climate Change, which demands that all states cooperate on the development of water resource adaptation plans, because there are many adaptation plans. Suppose in India there is Ganga rejuvenation plan that is going on, there is the Yamuna rejuvenation plan, there is a Ganga action plan, the gap is that is going on. So if there is any agreement with another state or in another country, then people should know and cooperate with that development of water resource. So it is very important to assess these difficulties that has been assessed. And if you read the Paris Declaration adopted at the COP21 in December 2015, if you read the text, you will find that water is not explicitly mentioned. Does this mean that water was not considered in the climate negotiation? No. In fact, the statement refers to the Sustainable Development Goal, that is SDG 6, and the objective says is dedicated to water. So it is not every time necessary that we talk just about water, that how the decisions have been taken regarding water, but we can just take about the United Nations goals as well, which clearly focus on the water usage. So reading the preamble of the Paris Declaration, human rights are mentioned, and it is clearly mentioned with the human rights. The human rights include the usage of water. Now, when we see this example, this is a very good example, the water charters in Africa, and how the water charters have been working and have worked in the recent time. Because when African states began to adopt or negotiate basin agreements in the 1960s and 1970s, very few rules on environmental protections were included. and you can see that how that 4.5% Africa's estimated economic growth in 2015, in millions the number of Africans could face water shortage by 2020, and that's today, because people are actually facing water shortages. And how extreme poverty, share of agriculture in Africa's employment, it is everything has affected the water usage that has came over time. Now, in this second map, you can see that how estimated economy, that is 2.6% growth in 2019, and 41% of sub-Saharan Africans live in extreme poverty. 61% of sub-Saharan Africans are using at least basic drinking water services. So you can see that how the water has been affecting now in the 4 years, just 4 years. The last data was of 2015, and now it is 2019 data, and how by it's such a huge margin this thing changed, like by 215 millions, by 61%, that is much more than 250%. Now how these things came, so there was the water charters that came into existence. Now water charter, because the reason for this was very simple. At this time, water was seen as an economic good in Africa. Just as in other continents, international river basin agreements contain very few rules relating to this water charter, and it was very important that because people were really dependent on the using of water resources. So it was very important that we looked on every port protocols, because and there were the formation of SADC, that is Southern Africa Development Community, and then from the protocols from 1992 to 2007, there were new things that came into existence. They started saving the aquatic ecosystems and the protection acts, that actually what is water charter, the protection of the environment and on the protection of ecosystems, that came into existence. And they learned it from a lot, because if we analyze the title water charters, we see that the emphasis is placed on water as an ecological resource. So when we see as water as an ecological resource, we tend to save it, and we don't see as water as an economic good, because there is a huge difference between ecological and economic. When we are seeing economic factor, we start exploiting things. But when we are seeing as water as an ecological resource, it is very important that we look, and when we see that how ecological factors can change the world, and how these things are actually the environmentalization of the international water law changed everything. Now, the most important thing I would like to say, that right to water and public participation is very important, because I have seen that there is an innovative measures that had been taken, and the law has been evolved at a greater perspective, and there is a huge change in law. So, but over the time, the right to water, the people exploited that right, because the people start using the water with actually no convention and with no usage, because when we are seeing that the wells that were in the earlier times, that were very far from workplaces, schools or homes, people were not able to use that much amount of water. But as soon as there was taps and everything was evolved over time, so there should be the application of international water law in each and every home, and it is very important to look at that greater perspective, because when we look and when we see this thing at the very greater perspective, that how these things can change and how everything could actually impact the universal framework. Because when the as we are the people, our public participation in international water law and our public participation in the right to water is very important, because there is no discrimination with water. There is no right of person with disabilities, or right of the child, or the right of convention. When we compare with right to water, there is no social or caste stigma attached to water. No, but water is an health, welfare, water endangering health of the environment or endangering health of the water just endanger your health. It is as deadly as any other virus. Now it is very important that we look at these things, and we see that how we can find against the pollution of water resource, and how these things could be looked forward, and how we can actually work on these aspects, and how these things could help us in a greater way. Now, how the settlements water related disputes could be end, and there are many articles. Suppose when we are talking about article 33 of the United Nations charters, which includes a non-exhaustive list of dispute settlement procedure. So we will often differentiate between diplomatic and jurisdictional methods to resolve disputes, and everyone will be knowing that what is diplomatic and what is jurisdictional methods to resolve disputes. Because when jury and when the justice came into existence, the judicial methods has a decision in binding. Because in the starting, what used to happen, that the negotiation used to take place, and there was used to be a one party or one lawyer from the one state, and suppose Pakistan, if we are seeing on Indus Water Treaty, and the one side and one lawyer used to be from India. So there was always the biased opinion, because Pakistan lawyer will say that we are right and we want this usage, and India lawyer will say that we have the right and we want this usage. So it becomes very impractical to get to the solution. So the International Court of Justice started this thing, that there will be one party from the one state, and there will be other party from the other state, and there will be the third party, that will be the neutral party. And the court requested that negotiations should be conducted, and the third party will assess that how the situation should be handled, and the third party will not be uh, any bias, so there will be no damages, there will be no mitigate effects, and this will reestablish the good management of international water course. Because when there the inclusion of the diplomatic nature by the court, so there will be the three parties that will be actually working on that. Now when we are seeing the diplomatic methods which are used in practice, we have to see that how the diplomatic methods it's different, and it has a different settlements, and you can see and you can read that how the settlements of disputes can in the non-navigational uses of international water course of 1997, that how this has affected over time, and how there is a different issue. Meanwhile, I would like everyone to please in the chat box, everyone be please write your name and your email address, so that I could just get the participants list, or you can just share your name in the comment section. And now I will be winding up with the webinar in 2 minutes. Now, the settlements of disputes is a very important thing, and when we see that alongside the diplomatic methods, they are used to settle dispute, there is also judicial methods, which is very important. Because the third party, a judicial third party, a court, a tribunal, who take binding decision for the parties, this is an important feature for the resolution of disputes. Because the decision issued, decided, and rendered by the third party will be binding on the parties to dispute. Now, among the judicial methods of settling a dispute, some are considered permanent decisions and some are mandatory. And there are the so called ad hoc proceedings, that is to say, before presenting these two judicial procedures. I would like to emphasize that states have always relied on judicial methods, yes, because states don't want any diplomacy. States don't want the solution to be by diplomatic methods. So if the countries are working, and if there is the countries are issuing the notice, and the countries are looking forward the negotiation, they want that everything should be worked with a judicial method, and there should be a judicial third party which could assist them to resolve differences, and there should be an inquiry procedure which is impartial. And I also hope that it will be impartial, because when we do this, there will be the commission of inquiry, and there will be the protocol appointed, and there will be different states that need to be worked. and the third member should originates with the defendant state, and it could attempt to sabotage. And if the third member will be from the defendant state, it could attempt to sabotage the procedure, and not by disagreeing to the appointment. That usually happens in the court cases as well, because in daily life also, when we use and when we see that there is different law commission set up, and there are different things that have been set up. So there is a huge issue and huge problem when the third party is not neutral, and there will be then the competence of international court of justice. And so this is very important to make the judicial system very transparent, that how this declaration allows the either the jurisdiction, and how the innovation can place in the commission of inquiry, and which can also recommendation. If we want to summarize the most important characteristic of the commission of inquiry, it is very important that how little things and how the justice took place in every circumstances. Now I would like to conclude this webinar by the like thank you for staying with me, and thank you for staying in this webinar, and I hope that I was able to share some knowledgeable content with you, and how this webinar has helped me also to gain knowledge, and to impart knowledge to the people out there. And it is very important that people know about international water law and how the international water law has helped over the time. And it's very important because when we see the articles, we examine the role of courts and tribunals in the settlement of water related disputes, and the various decisions made by these bodies have served to clarify and refine the rules and principle of international freshwater laws. And beyond that, we can see and we can hope that through these different sets I have covered in this webinar, we'll be able to answer your question on international freshwater law. And thank you very much. And at the end, I would like everyone to please just see what I'm going to share, and it will be a very important, and you will be quite interested to see that how India is affected by the water conflicts in and around the country. And I will show that how India has over the time seen and worked with the conflicts with Pakistan or with China. So I would like to share this with everyone, and I hope you will like this. Now you can see the water conflict chronology. I would just change it to Southern Asia. Now just see this, and this is a very important data, and everyone can just go and check worldwater.org, and this is the conflict map. So you can see that with India, the Pakistan had so many things. Now just see that device that in 2008, the explosive device detonates, destroying a tube well in Pakistan. And there was explosive setup in the Pakistan, and there was explosion in the state. Now when we see in India, it, in 2016, 18 people were killed and 200 injured after reopening of Munich Canal. Yes, the Munich Canal was opened, and there was such a fresh water supply, and actually this canal, and this is the type of casualty, weapon casualty. And you can see that how the people were affected, because New Delhi, with three-fifths of its fresh water supply, is dependent on this Munich Canal, and it was just stopped over that because the Haryana state said that they will not be using that water, and the 10 million people were left with no water usage. And this happened in 2016. Now there are many disputes that happened, and you can see this is in the 2012 attack, and the Pakistani militant attacks water system in Kashmir. Yes, so this was a very big issue because the Indus Basin, near the Indus Basin, between Pakistan and India this issue took place, and how this had created a war situation, because they just said that we want the water, and it would just disrupts their tribunal allegations, and how all these things will just affect them at a greater level. So this thing actually took place, and it was very very important, and very important conflict that took place, and it was quite astonishing, because the water after the water treaty itself, they were not able to follow these, because there was lack of international water law. Because if there would be proper law that was enforced on Pakistan, they would never been dared to do these type of casualties. And if I just change it to weapon, you can see this is this is in 1947 to 1960, what I was talking about, Indus Valley dispute that took place, that India is divided between India and Pakistan. And this actually, after 12 years of World Bank led negotiation, this thing came into the systems came into existence and flow. But this also acted as a war situation. And I would like to show in the 2012 disputes as well, that what happened in Tajikistan. This is also quite astonishing, that in Afghanistan terrorists just poisoned water at girls' school in 2012, and around 150 schoolgirls were reported sickened by poison. And these are the very big issues that have came into talk, because it was very important to know about this. And this is a 2019 situation, as everyone knows that the 40 Indian soldiers were killed, and 40 Indian parliamentary police were killed by a suicide bomb in Kashmir. And the people know about the Gulfama attack, and this was the very big thing. And the Pakistan claims India unexpected release of water from a dam is an act of war. And I don't know, and I won't want to say anything on this view, but this is a very important thing that people should know, that in 2019, this is a routine exercise actually, but the Pakistan wants to do war, because they know that the people of India is very angry, and they need to take action upon that. And it is very important that people look after this issue, because in 2019 the Pakistan claims that India has done the act of war by releasing unexpected water, but actually this was a routine exercise, because in monsoon the dam water had to be released. But this was claimed. There are many international water disputes that always happen in and around the world, and it is very important that people look after this. And people should know, and people should be aware about the water conflicts that are happening, because if I just talk about the southern Asia, or near India, you can see there are 124 conflicts. And if I just change it to all regions, so just imagine that this map had around 930 conflicts. So it is very very important that people see and people look after these issues, and people actually work and people learn about these issues in a greater and important way. Now I am open for Q&A. If anyone has any questions, I would love to answer that. If anyone have any type of questions related to any topic, please feel free to answer to question, and I will answer all the perspective and all the reviews. I would be sharing a feedback link by the end of the day. So you can just fill that feedback form. It will just take a minute or two, and I would love to have any type of feedback or questions, and I would love to answer each and every question. It is very important to look to the legal aspect of water, because when we are dealing and when we are just listening about the war situation that is happening between India and Pakistan and India and China, this is a very important approach that one should look, because when we are seeing this as a greater cause, this could be acting as a weapon for India as well as for China, because if we are not aware about the international water law, this is a potential threat to war, and UN can come also in the assembly. The groundwater law in India is not quite specified, but it depends on the state that what are the rules and regulations that are imposed in the state. Because in NCR region, the Delhi government, or the state government, they just have imposed that you cannot use the groundwater usage. It is prohibited or banned. So there should be a special permission, and on the special ground rules only you can use the groundwater. So actually the groundwater usage is prohibited in most of the states in India, but it is very important that to look at what are the legal aspects in groundwater resources that should be looked upon. Because when I'm living in Delhi, and there are many places the people are using groundwater resources, but they are aware about the complications that could imply with them if because the groundwater usage is completely illegal to use it for domestic purpose or any other purpose, or for any industry purposes as well. Now, what is the guidelines for using water? The guidelines for using waters, it depends on state to states, because if the state is implying and is using the water meters for the domestic purposes and for the industrial use, the guidelines will be completely different. Because now when we are seeing, and because when we are looking after the guidelines with the water meters, when we talk about India, so it is very important, because when we are talking in terms of India, uh, in Delhi, suppose water meters are installed, so the guidelines clearly respects that when we are using this much units of water, the guidelines are this, and there will be this much water charge. But when the water criteria increases or water consumption increases, then there are different guidelines that are set. And in the areas where there is no water meter usage, I think in the state like Uttar Pradesh, which is a very big state, and there should be the proper guidelines there, but there are no proper guidelines, although they generate the water bills, yearly annual water bills, but there is no specified guidelines. But in most of the states, the groundwater usage is prohibited, and you it depends on industry to industry, because if we are seeing as the groundwater guidelines, as we are seeing a water guidelines, the for the pollution, in the pollution level, in Ghaziabad area, in Surat, there were many factories and many textile plants that were shut down due to pollution, because they were just the polluted water, the dye water, they were just excreting out, polluting the ground water as well and the area. So they were entitled to use the water treatment plants, and they had to give a zero discharge, zero polluted discharge. So there are different guidelines for different states, and there are guidelines actually, but people are not actually exactly aware about it until unless there are legal consequences faced. Any other question? I would love if anyone had any type of query, you can just mail me. I think if we don't have any question, we can just end the session here. And thank you everyone for attending the session. And it was a wonderful experience, and the great response I have seen. And if you're interested in more webinars on water related issues, and we will be coming with more water policy making and different new approach that how we can deal with water, and how new things could come into existence. And we will be discussing new water issues that has been arising in the country, which are very overlooked, and we will be discussing about it. And so if you like the webinar, you can just share it with your needful people. And please like the webinar if you like it, and please subscribe to the channel, because we will be coming with more seminars here only. And thank you everyone, thank you for attending the webinar. And if you have any question and queries, please the feedback form will be shared, so please try to fill it. Thank you everyone.